Members of Assembly, would you take your seats, please? The Commissioner will be joining us very shortly. I wonder if you might stand for the arrival of the Commissioner.
President, members of the Assembly, I'm very delighted to be able to introduce to you Justice Peter McClellan. Justice McClellan is a judge of the Court of Appeal in New South Wales and, of course, is the Chief Commissioner for the Royal Commission on Institutional Responses to Child Sexual Abuse. It's been my privilege during my term as President to have a series of significant engagements with His Honour, and in that time I've been deeply impressed by certainly his care and frankly intelligence in the way he and the Commissioners have gone about dealing with their brief from the government. Many people here in this body would remember with great affection Sir Ronald Wilson, and I've thought of Ron many times. One of the things that struck me after he chaired the inquiry into the stolen generations was the way in which he allowed the stories that he heard as he moved around the country shape his understanding and his personhood, and in the way that he provided national leadership then in that space. And I've seen the same qualities in His Honour in the way that he's responded to the many harrowing stories that he's listened to. So it's with great pleasure that I present Justice McClellan.
Thank you. It's a privilege to be here to meet with you today. It's more than flattering to be mentioned in the same breath as Sir Roland Wilson. Sir Ronald was one of the great contributors to the Australian society. I speak to you today as the Royal Commission enters the second half of its 5-year term. As you are probably aware, the Commission was originally tasked to finish at the end of this year. However, the many and complex issues that we are required to examine led the Commissioners to ask the Government for a further 2 years to complete our work. The Commission will now conclude at the end of 2017. I have told the Government and my wife that there will definitely be no request for a further extension. Our terms of reference provide us with two fundamental objectives: to expose what has happened in the past and to make recommendations aimed at ensuring, so far as possible, that children are not sexually abused in institutions in the future. As with any Royal Commission, a significant part of our work is done through public hearings. A public hearing will be preceded by intensive investigation and research. Although it may only occupy a limited number of days of hearing time, the preparatory work which must be completed by the Commission staff and parties with an interest in the public hearing can be very significant indeed. The Royal Commission is now aware that sexual abuse of children has occurred in a great many institutions, all of which could be investigated in a public hearing. However, if we were to attempt that task, a great more resources would need to be applied over an indeterminate but lengthy period of time. For this reason, the Commissioners have accepted criteria by which appropriate matters are brought forward to a public hearing in what we call individual case studies. The decision to conduct a case study is informed by whether or not the hearing will advance an understanding of systemic issues and provide an opportunity for institutions to learn from previous mistakes. We must ensure that any findings and recommendations for future change that the Commissioners make have a secure foundation. In some cases, the relevance of the lessons to be learned will be confined to the institution, the subject of the hearing. However, in most cases, they will have relevance to many similar institutions in different parts of Australia. Public hearings also are held to tell the story of some individuals. They assist in a public understanding of the nature of sexual abuse, the circumstances in which it may occur, and most importantly, the devastating impact it can have on people's lives. When the Commission was appointed, it was apparent to the Australian Government that many people, possibly thousands, would wish to tell us about their personal history of sexual abuse. As a result, the Parliament amended the Royal Commissions Act to create a process which is called a private session. A private session is conducted by one or two, generally one Commissioner, and is an opportunity for a person to tell their personal story of abuse in a protected and supportive environment. We have now completed 3,766 private sessions. There are presently 1,527 people waiting in the queue. We receive applications for private sessions at a rate of almost 50 each week. I can also indicate that I have now referred 666 matters, most coming from private sessions, to the police in different states to investigate with a view to prosecution of an offender. You will read in your various newspapers, probably every week at least, of a new prosecution being commenced about someone for sexual abuse of a child. Not all, but of course much of the information that leads to those prosecutions is coming through our processes. The people who we talk to in private sessions cover a broad spectrum of Australian society. Each of them has been betrayed by a trusted adult. Each of their individual experiences has left a mark on their lives. For some, the lifelong consequences have been quite simply catastrophic. Each person's story is unique, with impacts of greater or lesser significance in their life journey, and with differing impacts upon their psychological and physical well-being. It is also reported to us that there are many people who cannot tell their story. They have taken their own lives. Commissioners sometimes hear the stories of people who, despite traumatic childhood experiences, have never lost their capacity to love and care for others. We have witnessed genuine humour and ingenuity amongst survivors, but we have also seen profound sorrow, grief and pain that for many may never go away. The label post-traumatic stress disorder does not convey the full extent of the suffering of these people. The link between childhood sexual abuse and physical and mental health problems later in life is now well established. Both Australian and international studies have found that amongst other debilitating effects, childhood sexual abuse results in higher rates of depression, eating disorders and social anxiety. Child sexual abuse has been linked to psychotic disorders, including schizophrenia. Although the impact of abuse on survivors has been the subject of academic research, it has not, in my view, been well understood in the general community. The assumption that penetrative sexual abuse of a child leads necessarily to the worst outcomes for survivors has only limited empirical support. That assumption is embedded in our criminal law in the various states and territories. In fact, abuse which many lawyers and legislators and others have traditionally regarded as relatively minor can have devastating and lifelong consequences for some individuals. Commissioners have also heard many stories from family members who have told the story of a loved one who has committed suicide. What is perhaps lesser known about the links between child sexual abuse and mental health is that it not only has impact on the person abused, but it can also lead to devastating impacts upon the survivor's family and others in their community. It is now apparent that when our task is complete, we will have documented a period in Australian society when institutions failed the children in their care. I do not mean to condemn every institution. It is clear that many were managed and sustained by the efforts of both volunteers and paid workers who understood how to manage an institution that provides for the welfare of children. But even then, we can recognise that many well-intentioned people did not understand and did not respond to failures which should have been obvious in the institutions of which they were part. Although some institutions operated as single entities, most have some integrated or overarching management arrangement or doctrinal regime. Failures may have been evident in the actions of one or a number of people, but that does not excuse those in responsible positions who failed to provide adequate policies to guide the institution and practices to inhibit the actions of offenders. From the work we have done, we know that there have been failures to protect children in residential facilities, schools, including particularly boarding schools, Christian churches of every character, Jewish organisations, kindergartens, after-school care, sporting organisations, dance classes, music organisations, scouts, hospitals, and many other institutions. There is no difference in the nature of the allegations nor in the mechanism for institutional failure between institutions conducted by the government and those in the private sector. When the institution provided residential care, it is common to find sexual abuse accompanied by high levels of physical abuse and exploitation of the children's labour, often for little, if any, reward. A picture is emerging for us that although sexual abuse of children is not confined in time, regrettably it is still happening today, there has been a time in Australian society when the conjunction of prevailing social attitudes to children and an unquestioning respect for authority of institutions by adults coalesced to create the high-risk environment in which thousands, tens of thousands of children were abused. The societal norm that children should be seen but not heard, which prevailed for unknown decades, provided the opportunity for some adults to abuse the power which their relationship with the child gave them. When the required silence of the child was accompanied by an unquestioning belief by adults in the integrity of the carer for the child, be they youth worker, teacher, residential supervisor or cleric, the power imbalance was entrenched to the inevitable detriment of many children. When amongst adults who are given the power, there are people with an impaired psychosexual development, a volatile mix is created. Although the primary responsibility for the sexual abuse of an individual lies with the abuser and the institution of which they were part, we cannot avoid the conclusion that the problems faced by many people who have been abused are the responsibility of our entire society. Society's values and mechanisms which were available to regulate and control aberrant behaviour simply failed. This is readily understood when you consider the number of institutions, both government and non-government, where inadequate supervision and management practices have been revealed and acknowledged by contemporary leaders of those institutions. It is confirmed by the development in recent years of regulatory control by government over many institutions which provide for children, and the development of education programs and mechanisms by which problems can be more readily brought to attention. The most obvious of these is the Working with Children check regulations, but there are many others. I am sure that we all hope that from the tragic personal stories and institutional failures revealed in our public hearings, the community will be reminded that both individual institutions and governments failed in their responsibility for children. Where once silence was demanded, a child's complaint, however tentative in its communication, must be heard and given an appropriate response. Whatever the nature of the institution and however its members are respected by the community, we must all accept that there may be members of trusted institutions who fail in their duty towards children. The power of the institution must never again be allowed to silence a child or diminish the preparedness or capacity of adults to protect children. The Royal Commission has so far received 13,256 allegations that fall within our terms of reference. Approximately half of these allegations relate to faith-based institutions. We have received 399 allegations in respect of abuse by members of Uniting Church institutions. This figure represents approximately 3% of the total number of allegations. In addition, we have received 106 allegations in respect of abuse by members of Presbyterian Church institutions and 62 in respect of abuse by members of Methodist Church institutions, the majority of those relating to events occurring prior to 1977. Of the 399 allegations, 173 relate to institutions involved in out-of-home care. 164 relate to boarding schools. The Uniting Church with the highest number of allegations is Knox Grammar School, with 137 allegations, no doubt contributed to by the fact that that school was the subject of a public hearing which brought forward many people to talk to us after the hearing had concluded. That hearing was held in February. In total, we have received allegations in relation to 130 institutions which are either Uniting Church, Presbyterian or Methodist institutions. During the course of our work, the Commissioners have learnt much about the way in which an institution's culture may contribute to or facilitate the abuse of children in its care. We know that enhancing institutional accountability encourages positive changes in institutional behaviour. The inevitable question is, in what circumstances, if any, should an institution be made responsible for the sexual abuse of a child by a member of that institution? If it is the case that an institution should be made responsible, how, as a society, should we require that institution to take that responsibility? Is it preferable that survivors use the civil justice system? Is that system operating fairly for survivors of child sexual abuse? Should we create a redress scheme? And what about the criminal law? These are some of the very significant issues which the Royal Commission has under consideration. I wish to speak a little bit about some of those matters today. Our terms of reference require us to consider justice for survivors. There are three avenues through which justice can be provided. The first two are the civil and criminal justice systems. However, legal proceedings often present insurmountable challenges, both financial and emotional, for survivors. There can be no doubt that for many people, their only opportunity for justice will be through an effective redress scheme. The issue of redress raises many complex questions. They include who should be eligible, how should a scheme be funded, who should manage it, and what benefits should it provide. Two key requirements have been identified. The first is that the scheme must be structured in a way to ensure its independence. The institution in which abuse occurred should not be the scheme's decision maker. A conflict of this nature has been a troublesome aspect of some redress schemes in the past. The second requirement is that survivors should be treated equally regardless of the institution in which they were abused. There are a number of forms that a redress scheme might take. One approach favoured by almost all of the institutions and survivor groups that we consulted with is a national scheme administered by the Commonwealth but funded by the relevant institutions, including the various governments where institutional failures have occurred. And they are a significant component of any institutional contribution to a scheme. This is self-evidently the approach which will meet the objectives of equal justice for survivors. Each institution's contribution to the cost of the scheme, including its administration, should be in proportion to the number of survivors abused in that institution. Of course, some survivors will have been abused in institutions which no longer exist, or institutions which actually have no money. Ensuring funding for these survivors is a fundamental requirement of a just scheme reflecting a just society. For redress to be effective, it must respond to the ongoing needs of survivors. It is clear that survivors need an apology from the institution. There must also be funding for counselling and psychological care. A money sum which adequately recognises the wrong done to the individual is also essential. It is now accepted that abuse can impact a survivor's personal development in a number of ways. It can affect an individual's ability to complete their education, to maintain a job, and to establish personal relationships. A monetary payment by the institution can serve the dual purpose of both recognising the harm suffered by the survivor, as well as providing financial assistance to the many people who, as a result of their abuse, are struggling to secure the basics of life. Our recommendations on redress will be made public after the publishing of the Commission's final report on redress and civil litigation, which will occur very soon. Our report will be provided to Government within a matter of weeks. In the last 20 years, there have in some countries been significant developments in the law relating to the liability of institutions for the sexual abuse of children by members of that institution. The courts in both the United Kingdom and Canada have developed the law so that, depending on the circumstances, an institution can be made liable for the deliberate criminal act of a member of that institution, even when the institution itself has acted without negligence. This is not currently the position under Australian law. While the High Court judges in a case which is called Lepore, which is the leading Australian case on this issue, divided in their reasoning, a majority did not consider that what's known as vicarious or strict liability should be imposed on an institution if a child entrusted to its care was sexually abused. The issue is often framed in terms of whether it is fair for an institution which has not been negligent to be made liable for the criminal act of a member of that institution. However, others will say it needs to be borne in mind that the relationship between a child and an institution will typically come about because of an offer made by the institution to care and provide a safe environment for the child. Prior to its consideration by the High Court, the Lepore case passed through the New South Wales Court of Appeal. The Court of Appeal, by a majority, held that the state of New South Wales was liable for the sexual abuse committed against a pupil by a teacher employed by the state. President Mason addressed the fairness issue directly. His Honour stated that arguments that it is unfair that an employer should be held responsible lose their force when it is recognised that most employers will not bear the cost personally. The insurer will, and that while an employer may be innocent, so too is the plaintiff who was abused as a child. The issue was starkly brought into focus by the discussion in one of our round tables. A woman with a senior management role in a childcare provider was asked the question as to what she believed was the appropriate response of the law in the event that a child was sexually abused while in care. She responded that as the manager of such an enterprise, without negligence by the provider, she would not want the provider to be liable for the deliberate criminal act of a member or employee of the institution. However, her position was different when she looked from the position of a mother. As a mother of a child who she had placed in the care of the provider, she would definitely want the provider to be liable, even if it had not itself been negligent. Again, the Commissioner's recommendations on this issue will be made plain when our report is released. A second issue that has arisen in the civil litigation context is the availability of a defendant that a survivor can sue. This issue is particularly acute for survivors who were abused by persons associated with faith-based institutions. While it is true that a survivor will always have a cause of action against their abuser, there are a number of practical reasons why they may either prefer or only be able to sue the institution in which their abuse occurred. Their abuser may be dead. They might, and this is often the case, have no money, or particularly when the abuse occurred when the survivor was very young, the abuser may not be able to be accurately identified. Under the law in Australia, unincorporated associations, including many religious organisations, do not have a distinct legal personality. As a result, they cannot be sued. It is common for their assets to be subject to a trust created by statute. This can result in a significant impediment for survivors who wish to pursue legal proceedings against some faith-based institutions. And although I do not have a detailed knowledge of the structure of the Uniting Church, I do understand that your church is probably in a similar situation. The issue arose or has arisen in a number of the Royal Commission's case studies. In case study number 8, we heard evidence concerning Mr John Ellis's attempts to recover damages for the abuse committed against him by an assistant priest within the Sydney Archdiocese. Mr Ellis could not sue the Catholic Archdiocese of Sydney because of its unincorporated status. As a result, he commenced proceedings against alternative defendants, including the trustees of the Roman Catholic Church, a statutory body corporate established under the Roman Catholic Church Trust Property Act, which is a New South Wales Act, and he also sued the then Archbishop of Sydney, Cardinal Pell. The New South Wales Court of Appeal held that the trustees were not liable for Mr Ellis's abuse, as they played no role in the appointment or oversight of priests at the relevant time. Nor could Mr Ellis sue the then Archbishop of Sydney, who had not held that position at the time of the abuse. As a consequence, Mr Ellis's litigation failed. In another case study, the Commission heard of similar difficulties faced by claimants in proceedings against the Christian Brothers in institutions in Western Australia. The court in that case held that the Archbishop of Perth could not be liable for the abuse suffered by the claimants. He was not liable as a natural person, as he was not in the position of Archbishop at the time when the abuse occurred, the same situation as Cardinal Pell. Nor was he liable as the corporation's soul, which was responsible only for landholding and not for the operation of the relevant institutions. The Royal Commission sought submissions on this issue in a consultation paper. Our report, which as I've indicated will be with government in a few weeks, will again contain recommendations on this issue. I won't preempt those recommendations today. However, I am pleased to see that some institutions, including Roman Catholic institutions and Anglican Church dioceses, have already made changes to make it easier for survivors to pursue claims against them. The promise of the Truth, Justice and Healing Council, the body of the Roman Catholic Church, which was set up to respond to the Commission, the promise of that body has been that the Catholic Church will make available a defendant in any case and a defendant which has money to meet a claim if the claim should succeed. In his evidence to the Royal Commission in the case study concerning the Melbourne response, which is the response of the Catholic Church in the Melbourne Archdiocese, Dennis Hart, the Archbishop of Melbourne, stated that his Archdiocese had recommended that the Church throughout Australia provide an entity for survivors to sue. The Truth, Justice and Healing Council, as I've indicated, has made that position now the position of the church body. The Archbishop of Sydney, Anthony Fisher, has also stated publicly that it is the agreed position of every bishop and every leader of a religious congregation in Australia that we will not be seeking to protect our assets by avoiding responsibility in these matters, and that anyone suing should be told who is the appropriate person to sue and ensure that they are indemnified or insured so that people will get their damages and get their settlements. The Wangaratta Anglican Diocese has recently agreed to become incorporated, and I gather that that is in the process of occurring with other dioceses, Anglican dioceses in Victoria. As we pass our halfway point, and with the publishing of our final report on redress and civil litigation, the Commission will shift its focus to the criminal justice issues that our terms of reference require us to consider. We will soon publish a comprehensive research paper on sentencing for child sexual abuse in institutional contexts. The paper's been written by Professor Ari Freiberg, who's probably the leading criminal sentencing expert in Australia, Hugh Donnelly, an immensely knowledgeable man from the New South Wales Judicial Commission, and an academic, Karen Gelb. One issue explored in their paper is whether institutions should be held criminally liable in certain circumstances for the sexual abuse committed by a person associated with that institution. Historically, the criminal law has been concerned with the criminal responsibility of the person or entity who commits the relevant act. However, while criminalising institutional behaviour may seem like a significant step, it is not without precedent. Organisational criminal liability has been a tool deployed to enhance organisational discipline and drive organisational change in a number of areas of our society. This is the case with respect to environmental law and environmental offences. It's also the position in relation to workplace safety legislation. One option put forward in the paper by Professor Freiberg and others is to recast offences that currently impose criminal liability on individuals so that they would in future also apply to institutions. One can look at the Victorian Crimes Act to sections of that Act, one of which provides that a person in an organisation who has the power or responsibility to reduce or remove a substantial risk that a child will become the victim of child sexual abuse, of a child sexual abuse offence committed by an adult associated with that organisation, and who knows that there is a substantial risk that the person will commit a sexual offence against a child, must not negligently fail to reduce or remove that risk. When introduced to Parliament, the Victorian Attorney-General stated that one of the key aims of this new offence in Victoria was the promotion of cultural change in the way in which organisations who care for and supervise children deal with the risk of child sexual abuse. This aim could be further pursued by having the offence apply to the institution itself. It is obvious that the sanctions that would apply to an institution must differ from those that apply to individuals. Imprisonment of an institution, of course, is not an option, and the fine, which may appear an obvious tool, may have unwarranted and deleterious effects on non-profit organisations. But again, the law is already pointing the way. Professor Freiberg and his co-authors identified that probation orders have been developed as a sanction in the regulatory context. Probation orders operate or can operate so as to prevent a person from engaging in certain types of conduct for the period of that order. There are examples in the competition law and also in the Australian Securities and Investment Law. In the transport industry, supervisory intervention orders have been used as a sanction against persistent offenders. These forms of sanction represent creative ways of sanctioning an offending institution, with the focus of the sanction being the reform of institutional behaviour and the promotion of institutional change. Changes in the civil and criminal liability of institutions may operate to drive effective change and create a more responsive culture in institutions that care for and supervise children. The purpose is to impose a greater discipline on institutions to ensure that adequate policies and procedures are in place to limit the risk to children in their care and ensure that they respond appropriately and effectively to any risk that might emerge. Apart from the work we are doing in public hearings and private sessions, the Royal Commission has an extensive research program with a team dedicated to the development of appropriate policy outcomes. In the next few weeks, indeed very shortly, we will provide government with our report in relation to working with children checks. This report addresses the paragraph of our letters patent which requires the Royal Commission to inquire into what institutions and government should do to better protect children against child sexual abuse and related matters. Adequate recruitment, selection and screening practices are key elements of a child-safe organisation. Working with children checks are one tool that helps to ensure that the right people are selected to work with children. They have been considered in public hearings conducted by the Commission and have been a focus of investigation as part of our policy and research program. This is the first step in the development of comprehensive recommendations designed to create a safe environment for children. Many other issues are being addressed by our research and policy program. Amongst others, we are addressing complaint handling and support services. We also have projects addressing regulation and oversight of institutions and other projects addressing advocacy and support services for victim survivors. You can expect over the coming months we will ask the Uniting Church and many other institutions to assist in developing appropriate policy outcomes in these areas. The work of the Royal Commission has already brought a significant response from many institutions which provide services to children. The Australian Childhood Foundation reports a large increase in requests for its child-safe audits from institutions providing services to children. And I can see coming before too long a national and maybe indeed even a voluntary scheme whereby institutions will be audited and accredited against a set of principles which the Commission will help to develop, so that an institution offering its services to care for children, provide for their education, or in any way have responsibility for them, will be able to advertise that they have been audited and have been found to comply with an identified and agreed set of principles. That will be a very significant step forward. Of course, it will also involve a continuing process of monitoring and audit of organisations which seek to claim that they are adequately accredited. The Australian Childhood Foundation is also scoping a significant audit project with the Australian Sports Commission, which oversees 62 different sporting codes throughout Australia. This work follows similar efforts by the Australian Olympic Committee. Following the Swimming Australia public hearing, the Olympic Committee has required working with children checks for all coaches, staff and officials prior to their joining the Australian Olympic team for the Rio Games next year. The President of the AOC, John Coates, has engaged directly with the Commission to ensure that beyond that initial response, effective practices and procedures are put in place for all of the sports which operate under the banner of the Olympic movement. I was sitting in my office in Sydney one morning and John Coates rang me, and I've known him for quite a long time, and he said, "Peter, I was in a meeting yesterday of the Olympic Committee and we were talking about the Swimming Australia hearing, and he said, I realised that we don't have any practices or policies or instruction to our managers or coaches about the way they are to interact with children in their teams." And he said, what's worse is I'm about to take a team of young people to the World Olympic Youth Games the next week, and we don't have any rules or practices in relation to how those children should be cared for. It was a wake-up call for the AOC, obviously, but similar wake-up calls, I'm sure, are occurring to many institutions around Australia. Indeed, there are many other examples of institutions responding already to the work of the Commission. Following the YMCA hearing into after-school care in Sydney, that organisation has responded through its national body to review its management practices and organisational culture in relation to children. It has engaged an independent consultant to assist in that process. We have now completed 2 studies of the Salvation Army in Australia, both studies looked at its Eastern Command. There will be a further study which will examine the Southern Command. Following our first study, the Salvation Army has restructured its Professional Standards Office and reviewed its response to individual survivors. Similarly, the Christian Brothers and the Catholic Church have indicated that following the case study here in Western Australia, they would reopen cases already settled and examine whether their response has been appropriate. The Royal Commission held a public hearing into the Melbourne response, the Catholic response in the Melbourne Archdiocese. During that hearing, Archbishop Hart announced that he had appointed a Federal Court judge to conduct a review of their processes. Following the public hearing into the Retta Dixon home, which is a home for Aboriginal children in Darwin, the head of the Australian Indigenous Missionaries agreed to sell AIM property to help fund compensation for survivors abused in that institution. It also offered a national apology. After the hearing into St Joseph's Orphanage known as Nearcole in Rockhampton, the Rockhampton Diocese have appointed a coordinator to respond to allegations and complaints of abuse from people who lived for a time in their lives in that institution. In October last year, the Anglican Diocese of Grafton accepted the Royal Commission's recommendations that arose from its study into the North Coast Children's Home. The diocese has pledged to fully and completely implement the recommendations, and for that purpose they have engaged with their professional standards people. It's a very significant step for that diocese because it's a diocese in great financial trouble, but nevertheless the commitment has been made, and we were pleased to see it being made, and I'm sure the Anglican community will come together to ensure that commitment is met. During the Ballarat hearing into the Catholic Church, which has still a way to go, it's only in its first stage, the Sydney Archbishop Andrew Fisher ordered a complete review of the professional standards of the Sydney Archdiocese. The impact of the Royal Commission has extended beyond its impact on institutions entrusted with the care of children. For example, the New South Wales Government has proposed legislation that would require chief executives of organisations that deal with children to undergo the same screening as frontline staff. In announcing the proposal, the Minister referred to our report on Scouts Australia. I am also aware of the response which the Uniting Church has made and will continue to make to the work of the Royal Commission. I have been told that the Church has reviewed its practices and policies and, where thought necessary, introduced new policies to safeguard children. I also understand that the Church is focused on an appropriate education program to increase awareness of child-safe programs. Other significant changes, including the response of the Church to survivors, have been made. I am very grateful for the invitation offered to me to speak to all of you today. I express my sincere thanks for the time and effort your leaders have taken to ensure the Royal Commission is assisted in its work by the Uniting Church. I anticipate that all of you here today have been deeply affected by learning of the abuse of many children in various institutions and the damage, in many cases catastrophic, to so many lives. I greatly value, as do the Commissioners, the support of all of you as we work together. It's a joint effort to change the culture, policies and management within Australian institutions so that, as far as possible, the sexual abuse of children in institutional settings is a thing of the past. Thank you.